Contracts are special legal binding agreements between two or more parties, either natural or legal persons. This means that the parties to a contract can go to court if one of them doesn't perform under the contract. Performance is doing what you promised in the contract. To be officially recognized as a contract and not simply an agreement must must meet the essentials of a contract: offer and acceptance, meeting of the minds, mutual agreement, or mutual assent. As evidenced by either signatures or actions such as making or accepting payments, in addition to wet signatures, electronic signatures are also binding per the Federal Electronic Signatures in Global National Commerce Act (e-sign) and the corresponding Massachusetts Uniform Electronic Transactions Act (UETA). Appropriate use. Best practices include selecting a reliable and compliant e-signature provider that offers features such as encryption, authentication, audit trail, and verification. The e-signature method, process, and requirement should be specified and communicated clearly and explicitly in the contract, and the agreement and acknowledgement of the parties should be obtained. Moreover, e-signatures should only be used for appropriate and suitable types of contracts, and should be avoided for contracts that require special formalities or signatures, or that involve high risk or sensitive matters. Finally, a copy of a backup of the signed contract and e-signature data should be kept and stored securely and accessibly. Advantages. Range of benefits for contract management, such as expediting and streamlining the process, increase convenience and accessibility, and ensure compliance and auditability. E-signatures can provide a clear and traceable record of who signed when, where, helping to ensure compliance with legal and regulatory requirements and standards. Risks. Validity and enforceability may be called into question, particularly in cross-border transactions or in cases where courts, authorities, or parties don't accept them. Additionally, security and authenticity may be compromised, as e-signatures may be vulnerable to fraud, forgery, or tampering. Consideration is anything of value exchanged between the parties. Valuable consideration is money, even a small amount. Goods or services. Good consideration is anything of a generous, affectionate, or moral nature. A hug, words of wisdom, etc. Legal object means that the purpose of the contract must be legal. Therefore, a contract to do something illegal is not really a contract. Reality of consent and competence. Consent is defined as freedom from misrepresentation, misstatement of facts without intent to deceive, fraud, deliberate misrepresentation, undue influence, unfair advantage of the facts without intent to deceive. Undue influence, unfair advantage or influence over another due to the relationship between the parties, or duress, the threat of physical injury or any other threat. The parties to the contract must also be competent, sober, of sound mind, and of legal age or an emancipated minor. A valid contract that has all of the essential elements listed above and can therefore be enforced by court, legally binding. Void or voidable contracts, on the other hand, suffer from some problem and may not be legally binding. Void contracts are agreements that are intended to be contracts, but because they lack one of the first three essentials listed above, offer and acceptance, consideration, or legal object, they do not qualify as contracts and therefore are not legally binding. Avoidable contracts are also intended to be contracts but lack the last essential, which is consent and competence. This last essential is different from the others because the contract is still valid unless the party whose consent is in question requests that a court void it. For example, someone who signed a contract while drunk could either wake up and still be fine with the terms and go forward with the contract, or they could realize they made a huge mistake and ask the court to void the contract. Watch out on the exam. A voidable contract is valid unless a court voids it. Even if you have a valid contract, it still might be rendered unenforceable for a number of reasons. Simply having a valid agreement doesn't necessarily mean you will win in court. For example, a court might decide the contract is unfair or that the performance is impossible. Another way that a contract might be deemed unenforceable is under the Statute of Frauds. Remember, the Statute of Frauds is the law that requires certain types of contracts, including real estate contracts, to be in writing in order to be enforceable. A verbal real estate contract is therefore unenforceable but not void under the Statute of Frauds. In practice, the difference between an unenforceable agreement and a void agreement isn't terribly important. In either case, the contract isn't protecting you from what has gone wrong and what has brought you to court. But on the exam, you need to make sure to differentiate between the two. The doctrine of laches is the idea that you lose your rights if you fail to assert them within a reasonable time frame, and can also be used to render a contract unenforceable. It can also be important in contract disputes. For example, if you signed a contract while drunk 30 years ago, it might not be terribly reasonable to ask a court to void it today. After all, it has been 30 years. That's a long time. Laches might therefore be used as a reason to deny voiding the contract, since you voided an unreasonable amount of time to assert your right to void the contract. What's unreasonable? It's ultimately up to the judge, so consult an attorney before using this one. Statute of limitations is different from the doctrine of laches. While the doctrine of laches is based on what is reasonable in a particular situation, a statute of limitations is a hard legal limit on when you can bring a certain claim to court. For instance, in Massachusetts, you might have up to 20 years to file a lawsuit after someone violates a contract, depending on the type of contract. After that, statute of limitations has elapsed, though the contract is unenforceable and you cannot file a lawsuit over the violation. Any promises made in a contract can be unilateral or bilateral. Unilateral contracts are those in which one party makes a promise to do something, while the other does not necessarily make any promise. For example, an option, an open listing contract. Bilateral contracts, on the other hand, involve a simultaneous exchange of promises. For example, a 12-month lease exclusive to sell contract. A 12-month lease exclusive right to sell contract. Executory contracts are contracts that have been agreed to but not yet completed, like when you are in the middle of a 12-month lease. Executed contracts are completed and finished. You've moved out of your leased apartment and all of the terms of the lease have been satisfied. Don't confuse the term executed with the term accepted, signed. People often use them interchangeably, so the test will try to trip you up on this. Contracts can also be assigned, which is the transfer of party rights and obligations to another party. However, the assigner, person assigning the contract, is not relieved of their obligations should the assignee fail to perform under the contract. Contract violations. The purpose of a contract is to provide a remedy in the event that one of the parties doesn't do what they agreed to do, known as a breach of contract. It's weird to think about, but contracts are made to be broken. After all, you don't need a contract if everyone does what they promise to do. The contract only becomes important when someone doesn't do what they've promised, and you wind up in court. The doctrine of privity of contract, gives the parties in the contract the right to sue for a breach of contract. In the event of a breach of contract, the innocent party may demand any number of things in court. Rescission, a cancellation of the contract, or rescission, a cancellation of the contract. Typically, rescission will involve both parties signing mutual release papers or mutual release agreement, relieving each other of their obligations under the contract. Specific performance, a court order forcing the party in violation of the contract to comply with its terms, commonly used if a seller attempts to back out of a sale. This is a type of injunctive relief, a court-ordered act, or a court-ordered cessation of an act. Damages. Monetary compensation for the harm suffered as a result of the breach of contract. Liquidated damages, a pre-agreed amount of money in the event of a breach of contract. Forfeiture, a type of liquidated damages where you lose your deposit. In real estate transactions, the deposit that would be lost is typically the buyer's earnest money, a deposit that they make when submitting an offer or signing a purchase and sale agreement. Common clauses. There are a handful of common clauses or stipulations to be aware of in contracts. Ironclad merger clause, integration clause, merger clause, or entire agreement clause states that there is no prior agreement in place, and any other agreements outside of the current written contract, for example, verbal statements at closing, shall not have any force or effect. Severability clause. By default, if one part of a contract is illegal, the entire contract is voided. See the section about legal object above. However, if the contract contains a severability clause, the clause provides that any part of the contract that is illegal will be voided, but the remainder of the contract will remain in effect. This way, the whole contract won't be thrown out if one small section in it is found to be illegal. Contingency clause makes the contract agreement contingent or reliant on something occurring. These include mortgage contingencies, inspection contingencies, and more. Generally speaking, contingencies that rely on the approval of a third party, example, an inspection, should have short deadlines to prevent unnecessary delays. Types of real estate contracts. Listing or selling contracts. Real estate listing contract or broker employment contract. The contract used to hire an agent to sell a home. Listing contracts usually cover what property the agent is selling, what they will be paid as a flat fee or percentage of the sale, the agent's authority, putting up for sale signs, holding open houses, etc., and the deadline for the sale, the listing's expiration. A multiple listing clause within the contract permits or requires cooperation with other agents via the MLS multiple listing service. Listing agreements typically take one of four forms. Flat fee listing, entry only listing. A listing where the agent is paid a fixed fee rather than a percentage of sales price. Usually, in this type of listing, the property is simply listed on MLS, and the agent does not show the property or negotiate a sale. Open listing, a listing where the seller hires multiple agents and they all work competitively to earn the commission based on the terms specified in the listing. Open listings are the only type of listing that can either be written or verbal because they are not exclusive listings. All other types are exclusive and therefore must be written. Note, the statute of frauds does not apply to open listings because listing agreements are hiring contracts, not real estate contracts. If the seller finds a buyer without an agent's help, if a seller finds a buyer without an agent's help, no one earns the commission. Exclusive agency. The seller hires one agent who will earn the commission. In most states, including Massachusetts, exclusive listings must be in writing and have an expiration date. Like an open listing, no commission is earned if the seller finds a buyer without the agent's help. Exclusive right to sell. One agent is hired to sell a property and they will earn a commission even if the owner sells the property during the contract term without the agent's assistance. An exclusive right to sell often contains a safety clause, sometimes called a protection or extender clause, that states the agent is owed some portion of their commission if the property sells shortly after the contract expires, to prevent the seller from waiting out the contract to avoid paying a commission. In most states, including Massachusetts, exclusive rights to sell must be in writing and have a specific expiration date. Buyer's agency contracts. Buyer's agency agreements are simpler than listing contracts. This is because buyer's agreements typically focus on exclusivity and are less focused on payment. Normally, the buyer's agent isn't paid by the buyer directly and is instead compensated by receiving a share of the listing agent's commission paid by the seller. On the exam, real estate commissions are treated as a cost for the seller. However, in practice, commissions are actually paid by both the seller and the buyer, which means both the buyer and the seller should be aware of the costs of hiring an agent. The split of the commission is negotiable between the two agents. Nothing legally prevents the buyer from paying the agent directly, and this does sometimes happen if the seller hasn't hired a listing agent and isn't paying a commission. But on the license test, the real estate commission is always a cost to the seller. Note that because both the seller and the buyer typically have an exclusive agent, in order for the agents to work on the transaction together, they must have permission to co-broke from their respective clients. Termination of broker employment contracts. Written listings and buyer's agency contracts typically outline the terms for the termination upfront. These terms can vary and are subject to negotiation. Some agents prefer to use at-will contracts where either party can cancel the agency agreement at any time. Others prefer to lock their clients in until the expiration date and don't allow the agreement to be canceled prior to the expiration date unless the client can prove that the agent breached the contract agreement. Either way, the agreement will automatically terminate at the stated expiration date unless it is renewed by mutual agreement between the agent and the client. On the other hand, if an agreement is verbal rather than written, for example, an open listing, it can usually be canceled at any time by either party. For salespersons, note that listing and buyer's contracts are broker hiring contracts. It is often up to the broker's discretion, not the salesperson, to cancel the contract because the agreement is technically between the client and the broker, not the salesperson. Remember, A real estate salesperson works on the behalf of their broker, and the broker is legally the agent to the principal. Offers. The listing is a solicitation for offers. Note that the listing is non-binding. Note that if the listing is non-binding, the seller does not need to accept any offer they receive. Under the offer, the buyer is the offerer and the seller is the offeree. The seller signs the written offer to accept it. Remember, verbal offers and acceptances are non-binding per the statute of frauds, which creates a contract to purchase. The contract mentions that the buyer and the seller will enter into a purchase and sale contract within a certain time frame, typically 5 to 14 days. The time frame can be shorter or longer than the average because ultimately the buyer and the seller negotiate this time frame. In a seller's market, typically the P and S will be signed in a shorter time frame than in a buyer's market, where the buyers desire more time to complete their due diligence. A seller may accept whatever offer they choose. However, once they accept an offer, they must perform under the terms of the offer and cannot unilaterally cancel it without cause. Typically speaking, time is of the essence, meaning that timely performance under the contract is required. Once an offer is accepted, it is no longer an offer, it is a contract. However, before an offer is accepted, it can be terminated by any of the following. The time limit stated in the offer ends, also known as the expiration date, the death of either party in the offer, the destruction of the object of offer, for example, the house burning down, withdrawal of the offer, counter offer by the seller. Counter offers automatically void the original offer, and the new offer would need to be created and signed. Agency relationships. The agent gets fired, loses their license, etc., have no effect on the offer. In some transactions, you will be presented with a shortened document known as a binder or letter of intent that serves a similar purpose to the offer. Handling multiple offers. There aren't any specific laws that dictate how a real estate agent handles multiple offers. However, there are best practices that can help agents cultivate lasting relationships with their colleagues and clients. Remember that if you are a member of the NAR, you'll be required to follow their code of ethics regarding multiple offers, which will be more detailed than the best practices indicated. Handling multiple offers as a real estate agent involves balancing act of transparency, effective communication, and ethical conduct. It is important to understand what's stated in your listing contract. For example, listing agent is able to disclose competing offers, or listing agent is able to disclose that there are offers on the table, but not the details of those offers. To start, set clear expectations and deadlines for all parties involved. For example, will the seller be taking offers as they come, or will they have an offer deadline? And maintain open communication throughout the process. As the agent objectively evaluate each offer, considering price, terms, and contingencies, while prioritizing the seller's interest and preferences. However, remember that while your expertise in the field is valuable to the sellers, how multiple offers are handled and which offer is accepted is ultimately up to the sellers. When representing buyers, explain that you or your brokerage may represent more than one buyer client, and it could be the case that multiple clients are interested in purchasing the same property. Be honest about how that would be handled. Encourage buyers to submit their best, since it is not always a given that a seller will counter all offers in a multiple offer situation. By staying organized, educating clients, and continuing continuously developing professional skills. Real estate agents can navigate multiple offers successfully, achieving the best outcome for all parties involved. Purchase and sale contracts. The purchase and sale contracts P&S is the agreement about how the sale will take place. Purchase and sale contracts outline the obligations of the buyer and the seller and any contingencies, such as financing contingencies, escape clauses, permitting the seller to continue marketing the property while it is under contract, inspection contingencies, etc., and the date of closing, sale of property. The basic essentials of a valid purchase and sale include the following: the name of the buyers and sellers, legal description of realty, i.e. its address, offer and acceptance, in writing per the statute of frauds, consideration, often a 5% deposit from the buyers, the terms and conditions agreed upon by the parties, any contingencies negotiated by the buyer or seller, the date of performance, closing. After the P&S is signed, the buyer and seller may amend it by attaching a separate agreement, a rider, or by writing in new terms and initialing the changes to the agreement. Rent-to-own and lease purchase agreements. Rent-to-own is a way for tenants to eventually buy the property that they are renting. In a rent-to-own arrangement, the tenant receives an option to buy the property as part of their lease in exchange for a fee. Then, if the tenant decides to exercise their option prior to their lease's expiration, their rent payments will usually contribute towards the purchase payment. A lease purchase agreement is more binding form of rent-to-own. In a lease purchase agreement, the tenant agrees to purchase the property at the outset of their lease instead of just receiving an option to maybe purchase the property in the future. So unlike rent-to-own, the tenant is in a lease purchase agreement and is obligated to purchase the property because they have signed two contracts simultaneously, a lease and a purchase contract. The tenant will also often be required to pay for property maintenance, taxes, and so forth as if they had already owned the property, depending on what is allowed under state and local laws and regulations. And generally, there is a cross-default provision. This means that if the original lease is breached, then there is also a breach of the purchase contract. Options. Options are a type of contract that you might encounter, though rarely. They are written contracts where the owner of a piece of property, optioner, in exchange for consideration grants another party, optionee, the right or lease grants another party, optionee, the right to purchase or lease a property within a certain time frame at pre-agreed terms. The optionee may then choose to exercise the option, purchase or lease the property, if not during that time frame. There is no obligation to exercise the option. Options may be assigned without the consent of the optioner. They might be used to buy time for a developer who needs to gain financing, or for a tenant who is interested in renting before owning to try out the home. An agent who brings an optionee rather than a buyer will only earn a commission if the option is exercised. The sales goes through. Rights of first refusal. A right of first refusal gives a prospective buyer the right to match any offers made on a property and to purchase the property at offered price in lieu of the original offerer. That said, the right doesn't give the buyer control over what price or terms the property sells for. They are limited to matching the best offer made on the property. Unlike options, rights of first refusal allow the owner to track the market and ensure market fair value, or choose not to sell. Rights of first refusal can also be used for rental properties. Rights of first refusal can be disadvantaged Disadvantages for sellers because potential offerers might see the delay and uncertainty created by the right of first refusal as a negative, and therefore choose not to make an offer on the property. This might reduce the demand for, and thus price of, a property. Typically, sellers only grant the right of first refusal if they are being very kind and if they are being compensated or if it is required to close the original deal. Rights of first offer. A right of first offer gives a prospective buyer the right to make an offer, purchase a property before anyone else, and typically requires the seller to make a good faith attempt to reach a deal with that buyer before putting the property on the open market. Rights of first offer can also be used for rental properties. Like rights of first refusal, rights of first offer are typically only granted as a courtesy for compensation or if it's required to close the original deal. Power of attorney. A power of attorney is a written document that allows someone to act in a legally binding way on behalf of someone else. It creates what is known as an attorney in fact and is often used to allow real estate agents to attend a closing and sign documents on behalf of their client. Okay. And then there is a sample sales agreement and a sample offer to purchase and a sample purchase and sale agreement. Okay, that was contracts.